quickly run through sort of the life of an investigation. It usually starts with whistleblowers these days. Leniency and immunity systems have been so successful that authorities actually receive more of these than they can effectively handle. So when an investigation does occur, expect the authority to be well armed and to already have a lot of information available to them. That's not to say that what they have is all they need, because even claims of the existence of a cartel need to be verified, and they need to be verified by reference to sort of other sources than the immunity application. So the authorities tend to go out, collect information. If they do dawn raids, it's not only to collect information, but also to send a signal to those who are involved. A signal to say, look, we know or have a very good idea of what's gone on, but you may wish to cooperate with the authority in order to sort of gain benefits later on when it comes to the fining process. So gathering of information, perhaps just as much as sort of the signal to other parties to please consider whether they want to cooperate. And that's what you then need to consider as the investigation progresses. Do you actually want to fight the allegations, or do you want to cooperate? And the way that leniency systems are structured gives particular advantages to those who come in first. So when the investigation starts, there is what has become known as a race for leniency, and that is sort of to very quickly decide whether you want to go in and cooperate or not in order to get sort of a maximum possible reduction of the fine. Then sort of the investigation progresses. You come to the stage where the authority reaches a preliminary conclusion, usually sort of gives parties an opportunity to comment on that. After that, usually in the national context, there may be discussions concerning a settlement where the parties and the authority agree basically on the contents of the decision and the value of the fine. Another opportunity to perhaps get the fine reduced a bit more in return for sort of an agreement not to fight against the decision. If you don't settle, then sort of a decision is issued, and the parties usually sort of get an opportunity to appeal. That was done sort of as a matter of course in the old days. What happened was, at least in the European Union context, that usually the fining of an infringement was upheld, but the fine was reduced a bit. So it made sense to appeal. That seems to be changing, and courts seem to sort of actually have another look at the fine and maybe even increase the fine. The power is certainly there, and the risk is there that you actually may end up paying more than if you had accepted the decision. That's sort of how an investigation basically runs. The question now arises, what do you do when you find out that there is an investigation, so at the very sort of start of the process? And we'll look at these 4 steps in detail on the following slides. So I'll just sort of give you very brief headlines. What do you do when you realize there is an investigation? First of all, find out what it's all about. How broad it is it? What does it concern? And what's sort of the risk that you're facing as a consequence of the investigation? Consider the potential consequences of the investigation. What is your exposure to fines, and how can you possibly reduce the sanctions? In that context, when you think about the consequences, don't just think about the fines, think about follow-on litigation as well, because that's part of the package these days. And if you look at the financial exposure, you need to consider that as well. On the basis of that, basically, you must develop your antitrust strategy. First of all, the question, is there an infringement? Am I going to fight the allegations, or am I going to cooperate? Is leniency an option for me going forward? You need to think about what others will do. Because as I said, it may be a race, others will do the same thing, and they may get there more quickly, getting sort of a bigger reduction of the fine if that's available. So you need to act quickly, but you also need to think about what the other parties are likely to do. And in a multi-jurisdictional context, you need to identify priority jurisdictions. You cannot assume that you can effectively deal with multiple investigations in parallel. You need to find out where you need to move first, where your risk is biggest, where the advantages of moving quickly are greatest, and then sort of assign priorities on that basis. And most importantly of all, assign sufficient resources to the internal team that handles the matter. Because as a rule, this will be not just very important to the company, but also very resource intensive. And you need to make sure that you have the right sort of manpower to deal with these things effectively. Looking at these points in more detail, first step to do is to assess the scope of the investigation. First of all, if you're looking at a multi-jurisdictional investigation, just understand which jurisdictions are affected. Where do you have investigations? There may be sort of multiple jurisdictions starting an investigation at the same time, but also sort of what's the potential scope of the whole thing. And what you need to do is to look at sort of the behavior, the potentially infringing behavior, and then need to look at the jurisdictions in which that behavior may have had an effect. A company may have complained in one jurisdiction or may have blown the whistle in one jurisdiction, leaving aside other jurisdictions, perhaps not being aware that the same problem existed in other jurisdictions, or perhaps having not enough resources to effectively deal with multiple jurisdictions at the same time. So you may actually realize that the problem is bigger than what's indicated in sort of the current scope of the investigations. And we've realized that experience shows that the whole thing becomes almost sort of a game of sort of aggression and retaliation, where sort of a whistleblower in one country is suddenly faced with counter investigations almost in other countries, or where sort of the other parties realize, hang on, there was not only a cartel in product X, but also sort of a cartel in products Y and Z. And in the course of their internal investigation, uncover those sort of other cartels, and then come forward claiming immunity or leniency for those other products. So things become actually very complex, and when you deal with investigations, it's very important to realize not only what it is that you're currently facing, but what the potential is that you might actually be facing, sort of in other jurisdictions or in other product areas. Have a look at sort of the seriousness of the infringements. Is this sort of a truly hardcore cartel where people have fixed prices, for example, which will attract very high fines, and where it's clear that there is an infringement? If the facts are proven, you have an infringement. Or are you facing sort of a more soft-core cartel, information sharing amongst competitors, for example, where there may be more room to argue that actually this wasn't anti-competitive or it didn't produce any effects, and where you actually sort of may have other options in terms of defending your company. The duration of the infringement is also very important, and it's not always established at the very beginning of sort of the investigation. An immunity applicant, for example, may have gone in and said, we fixed prices from 2005 to 2010 because that was the time that the relevant employee told them about. Now, perhaps his predecessor already ran the cartel back in the 1990s. And the immunity applicant never realized that, never actually sort of put that into his application. You may have a more complete picture, and you need to think about these things because it affects your exposure. And lastly, in this sort of instance, the question arises, what is already available to the authority in terms of information? Often you can find that out from court orders that authorized sort of the investigation in the first place. You also know if there has been a dawn raid, the authorities have visited your company. You also know what they took from you. So you already have a pretty good picture of what's available to the authority and maybe what's not. On that basis, you have a pretty good idea of what's affected by the investigation, either actually or potentially. Next step would be to calculate the fine. What's the risk that the company is facing? Usually, that's sort of a percentage of the sales that were affected. I think most jurisdictions, at least in Europe, follow that approach. When setting the fine, you start with the affected turnover and then sort of multiply that by certain factors. Of course, markup and reductions apply. Aggravating and mitigating factors. Was your company the ringleader? Did they coerce other companies to participate? Or were they merely sort of passive members of the cartel, which maybe even sort of adopted competitive strategies that were not in line with what was agreed? So all these factors come into play when you assess the potential fine, the risk that the company is facing. And then, of course, you need to understand what the risk for the individuals are. Often, when it comes to financial penalties, from a company's point of view, they are less significant. The company gets fined 10 million, the employee gets fined 250,000 euros. So the company fine obviously is bigger. The individual employee will not be happy to have to pay sort of what is for him a significant fine. And fines, I think, are just one part of the game. If local laws actually sort of threaten criminal sanctions, that, of course, has sort of even a bigger impact on the individuals. In this way, you can sort of fairly easily and straightforwardly calculate maximum fines, your maximum exposure. When you devise a strategy, you also need to think about the realistic exposure. And in that context, you also need to think about how likely other agencies are to pick up the matter in other jurisdictions, and how vigorously they enforce their respective competition laws. What's their track record in terms of fining previous cartels? You look at that in order to actually establish the likely fine that a company may be facing.